And it's kind of like, to bridge in briefly to the Twitter suit. So, yeah, what happened is the guy who discovered the Hunter Biden laptop, who reported it, is suing Twitter because Twitter originally refused to allow the New York Post story about his about his discovery of Hunter Biden's laptop to run on the grounds that he had hacked it. And so his point is that, Twitter lied about him. And so it's not a Section 230 suit. It's not about Twitter controlling the content on its site. It's about Twitter saying, if Twitter had just suppressed the New York Post without giving that disclaimer, then he wouldn't have had a suit. He had a suit because Twitter said the reason we're suppressing this is hacked information. And he said that was lying about me because everybody knew that was about me. So he's filed a very good. Now they have a big damages claims, and that doesn't usually go anywhere. But I don't think he can prove $500 million in damages. But I think it's a good place to start. When Twitter is using these disclaimers, making specific statements, they're getting into a different territory. It's one thing for Twitter to be effectively a publisher by what they censor, suppress, and support and reward. It's a totally different ballgame when they start making specific statements about people's posts or about people or about individuals or businesses. Then they are defaming, and Section 230 does not protect them. And so this is, I think, is the beginning of a sequel of attacks that will occur against Twitter for doing this, because they've gotten, and Facebook, this is part of Candace Owens' theory that you went through, where Facebook, it's the next step to her suits. Her suits right now are on the Facebook fact checkers, but then it's going to go to Facebook depending on what defenses are raised.
Well, I mean, the other thing is, it's going to. I hope they've read through Clarence Thomas's Supreme Court decision, because he basically laid out the argument that they should be making to say that none of this, when you do this specific conduct with specific tweets, it is no longer about moderating the content on the platform. It is about now editorializing it, and this may be the decision to get there, and it may make it sort of academic for 230 reform. Maybe the courts are going to come in and reform it themselves or interpret it properly, but they are obviously going to raise the 230 defense and try to have this dismissed on a motion to dismiss.
Yes, and I think that I think they'll survive. I think the defamation case will survive a motion to dismiss, or should. We'll see what ultimately happens. And if it didn't, then it does set up very good appellate grounds, because clearly that would be a misapplication of Section 230 to allow Twitter to now defame people openly and overtly. And so we'll see how it translates. But very good suit, and good to see it start suits like that to start as part of the legal fight back against big tech. And it's another good reason why Hawley objected. Hawley objected because part of the issues he's going to document in the record is that big tech's suppression campaign and Zuckerberg, this was one of the questions that people asked on the locals board, Zuckerberg selectively spending money under a guise of a charity to influence how elections were conducted in a bunch of key swing counties and key swing states that disproportionately favored Democratic voting methods, basically was a way for illegal campaign contributions to take place and occur. And real illegal illicit election influence happened in this election. And it happened in large part enabled by big tech, making effectively donations in favor of one candidate outside of the limits and without disclosing it as such. And I think Hawley is going to be part of detailing that in the congressional record, which is good to continuing to build the court of public opinion for change and reform in that area.
It's going to be good. And by the way, I've got my homework, but that's another one that I'm breaking down. I've read through it very quickly, but it's an amazing thing. It's what we've been saying for a while. This is not content moderation. This is actual curation, and they are saying things through what they do, and they're implicitly saying things through what they don't do. And this guy, can you imagine? You have your life ruined just because of who crosses your path. And after that, which intelligence agencies cross your path? It's an amazing thing. It's out of a movie. So we're gonna come back to this one also, because this is also the blueprint for what Clarence Thomas was saying. It should be the next case to be heard by the Supreme Court, because undoubtedly, in my mind, they're going to raise 230. I think they'll succeed at the lower levels, but it'll get up to the higher levels. And if it's nothing else than Supreme Court adjudicating on whether the 230 defense applies under certain circumstances, that will be the outcome of the case.